SEC issues memorandum on unfair debt collection practices. Manila, Philippines. The Securities and Exchange Commission (SEC) has issued a memorandum circular preventing unfair debt collection practices, such as the use of insults or profane language, violent threats, or false representation. In the new circular, the SEC said that financing companies, lending companies, and their third-party service provider could no longer harass borrowers and employ unfair means to collect debt. Financing companies, lending companies, and third-party service provider hired by them may resort to all reasonable and legally permissible means to collect amounts due them under the loan agreement, provided that in the exercise of their rights and performance of their duties, they must observe good faith and reasonable conduct and refrain from engaging in unscrupulous and untoward acts, the SEC said in the circular issued August 19. The SEC said such unfair debt practices include the use of obscenities, insults, or profane language, publication of the names and other personal information of the borrower, and the use of any false representation or deceptive means to collect or attempt to collect any debt or to obtain information concerning a borrower. Furthermore, the corporate regulator said that making contact at unreasonable or inconvenient times or hours before 6 a.m. or after 10 p.m. is not allowed. This is unless the account is past due for more than 15 days or the borrower has given express consent that the said times are the only reasonable or convenient opportunities to contact. The SEC said financing and lending companies found to be violating the circular face penalties ranging from 25,000 for lending companies and 50,000 for financing companies for the first offense to 50,000 up to 1 million for both for the third offense, and possible suspension or revocation of their license. The SEC issued the circular because it has been receiving numerous complaints against financing and lending companies that allegedly harass borrowers and employ abusive, unethical, and unfair means to collect debts. It said the SEC has regulatory and supervisory jurisdiction over these companies by virtue of Republic Act 8556 or the Financing Company Act of 1998 and Republic Act 9474 or the Lending Company Regulation Act of 2007. Last May, the National Privacy Commission (NPC) said it also looked into 48 online lending applications that allegedly shamed borrowers who failed to settle their obligations on time. The agency has received over 400 complaints from borrowers over alleged misuse of their personal information, including disclosure of their unpaid balances to other people, he said. How to stop debt collector harassment. Number 1. Write a letter requesting to cease communications. Number 2. Document all contact and harassment. Number 3. File a complaint with the FTC. Number 4. File a complaint with your state's agency. Number 5. Consider suing the debt collection agency for harassment. What is considered debt collection harassment? The definition of debt collection harassment is to intimidate, abuse, coerce, bully, or browbeat consumers into paying off debt. This happens most often over the phone, but harassment could come in the form of emails, text, direct mail, or talking to friends or neighbors about your debt. A debt collector can't harass you. Now, for a few rules that apply to any debt collector, including collection agents. First, they can't communicate with you in a way that amounts to harassment. Harassment can include using threatening, intimidating, or profane language. How do I fight a false collection? Reach out to the company the collector says is the original creditor. They might help you figure out if the debt is legitimate and if this collector has the right to collect the debt. Also, get free annual credit report online or at 877-322-8228 and see if the debt shows up there. Dispute the debt in writing. Can debt collectors threaten you? Even if you do, debt collectors aren't allowed to threaten, harass, or publicly shame you. You can order them to stop contacting you. Can debt collectors go to your house? The short answer is no. A debt collector cannot take your house. However, a creditor whose loan is secured by your house can foreclose on the loan and take the house. And depending on your state laws, a debt collector without a security interest in your home may be able to put a lien on it.